Hello everyone, welcome to Manovidya IAS. In this video, we will be looking into the details of Citizenship Amendment Bill, and we will also analyze the impact of this bill on different sections of our society. Let's look into the context of the topic. Yesterday, Lok Sabha passed Citizenship Amendment Bill 2019 amidst huge outcry from the opposition. Keeping this in view, let's look into the features of the bill which made many political parties and civil society to oppose the bill. The bill seeks to allow six religiously persecuted communities from Pakistan, Bangladesh, and Afghanistan to apply for citizenship through naturalization by amending Citizenship Amendment Act 1955. The six communities are Hindu, Sikhs, Buddhist, Jain, Parsi, and Christians, and they should have entered India prior to December 31st, 2014, and should have stayed for 6 years in India. And also, they don't require any proper document. That means they can be legal immigrants also. Here, the current requirement for acquiring citizenship through naturalization is 12 years, but this amendment has reduced that period to just 6 years for those minority communities. Next, it proposes to drop all cases against non-Muslim illegal migrants, including cases at foreigners' tribunals once they get Indian citizenship. Another feature related to overseas citizens of India is registration of OCI card holders will be cancelled if they violate any law. However, they will get an opportunity to be heard. Owing to the opposition by northeastern states, government kept some exceptions regarding applicability of the act. With this, tribal areas of Assam, Meghalaya, Mizoram and Tripura, which have been included in 6th schedule of the constitution, are exempted from this bill. And certain areas of Arunachal Pradesh, Mizoram and Nagaland, which requires inner line permit to enter, are also excluded from the bill. And while presenting the bill, Home Minister assured that inner line permit will be extended to Manipur, and hence this bill will not be applicable to Manipur also. In this backdrop, before getting into the analysis of the bill, let's discuss about citizenship in India, Citizenship Act of 1955, Schedule 6 of the Constitution, as well as the concept of inner line permit. Now, let's look into the concept of citizenship in India. As per the Constitution, citizenship signifies the relationship between individual and state. Our Constituent Assembly accepted citizenship on the basis of place of birth, that is, just solely, and rejected citizenship on the basis of blood ties, that is, just sanguineous. And they have listed citizenship in the union list, which means central government solely has the authority to decide on the citizenship. When we look at the constitutional provisions, in part 2, Article 5 to 11 talks about citizenship. Let's look into these articles one by one in a brief. Article 5 of the Constitution talks about citizenship on commencement of the Constitution. In this, a person who is born in India, or either of whose parents was born in India, or an individual who resided in India for at least 5 years preceding such commencement will get the citizenship of India. Next, Article 6 talks about the rights of citizenship of certain persons who have migrated to India from Pakistan, whereas Article 7 talks about rights of citizenship of certain migrants to Pakistan. Article 8 talks about citizenship rights of certain persons of Indian origin residing outside India. And Article 9 says, any person who voluntarily acquires the citizenship of a foreign state will no longer be a citizen of India. That means the Constitution of India does not allow dual citizenship. As per Article 10, the continuance of citizenship rights is subject to the provisions of any law made by the Parliament. That means Parliament can take away citizenship right by making legislation pertaining to that matter. Next is Article 11. As per this article, Parliament can make any provisions with respect to acquisition and termination of citizenship and all matters relating to that. By taking cognizance of Article 11, Parliament enacted Citizenship Amendment Act 1955, and this has been amended in 1986, 2003, 2005, 2015, and now in 2019 in order to accommodate to the current circumstances. As per this act, there are 5 ways to acquire Indian citizenship and are: first one, citizenship by birth. As per this, till 1987, anyone who born in India, irrespective of their parents, except foreign diplomats, got citizenship. After 1987, Citizenship was given to a person with a condition that one of his parents is an Indian. In 2004, one more condition was added, and that is the person should not be an illegal migrant. Next, citizenship by descent. If the birth occurs outside India and one of his parents is an Indian, then he can apply for citizenship with the nearest consulate. Next is by registration. This is for foreign citizens. In this, persons of Indian origin who stayed in India for 7 years can apply for citizenship. Persons married to Indians can apply after 7 years of stay. Minor children of Indian parents can get citizenship through registration. Overseas citizens of India can apply for citizenship after 5 years of stay. And finally, any other minor child in special circumstances can get citizenship through registration. Fourth way of getting citizenship is through naturalization. Any foreigner can apply only after 12 years of staying in India. Now, through this amendment, the time period has been reduced to 6 years for those communities from Pakistan, Afghanistan, and Bangladesh. Finally, citizenship can be provided through incorporation of territory. As per this, if India acquires any territory outside of India, then the people residing there will get Indian citizenship. However, Center has the authority to deny citizenship to anyone in that territory. Next, there are three ways for losing citizenship. First one is renunciation. According to this, a citizen can renounce citizenship by making a declaration that effect in having it registered. Second one is termination. If a citizen voluntarily acquires citizenship of another country, he or she shall cease to be an Indian citizen and it is terminated. Last one is by deprivation. It applies to citizens who are naturalized or registered. If it is found that they acquired citizenship by fraud or wrong documents, or if a citizen joins enemy during war, then his citizenship will be deprived. Now, in the present bill, tribal areas in 6th schedule have been excluded. Let's look into it in a detailed way. India's population consists of 100 million tribal people who have constitutionally been addressed via 5th and 6th schedule. In this, 6th schedule covers areas that are settled in the northeast states bordering China and Myanmar, and it gives considerable autonomy to tribal communities present in the states of Assam, Tripura, Meghalaya, and Mizoram. Those areas are regarded as district councils and regional councils. Currently, there are 10 such councils in the region. In Assam, there are 3 such councils: Bodoland Territorial Council, second, Karbi Anglong Autonomous Council, third one is Dima Hasao Autonomous District Council. In Meghalaya, Garo, Jaintia and Khasi Hill Autonomous District Councils are there. In Tripura Tribal Areas Autonomous District is there. Whereas Mizoram has Chekma, Lai and Mara Autonomous District Council. Here, the application of any central act to these areas is decided by President, and the application of any state act is decided by Governor of the state. One more exception to the current bill is inner line permit. As per this, certain areas of Arunachal Pradesh, Mizoram and Nagaland which requires inner line permit to enter are exempted from this bill. Here, inner line permit is an official travel document issued by government of the state to people of other states and foreigners, and this is mandatory to enter into some protected areas within Arunachal Pradesh, Mizoram and Nagaland. This inner line permit system is established by the center by an executive order. These protected areas have been set up under ILP system to protect economic interest, culture and language of native ethnic groups. During British era, ILP system was introduced through Bengal Eastern Frontier Regulation 1873 to protect commercial interest and to avoid exploitation of natural resources in those areas. At present, ILP is required to enter areas within 3 states, that is Arunachal Pradesh, Nagaland and Mizoram. Now, as per the assurance of Home Minister, Manipur will be included in the ILP system, and this was also a long-standing demand of Manipuris, especially Meitei tribes. And yesterday, Nagaland extended ILP to Dimapur, which is commercial hub of Nagaland. By this, as far as northeastern region is concerned, the bill applies to non-tribal areas of Assam and Tripura only. Now coming back to the bill, it has been criticized all over the country and especially in northeastern states. So let's look into these criticisms. First, it violates the basic structure of the constitution under equality and secularism. In this particular bill, Illegal immigrants are distinguished based on religion, and our constitution does not entertain citizenship based on religion as it shackles the secular nature of our country. Secondly, it violates Article 14 of the Constitution, which talks about equality before law and equal protection of law. The argument of the critics is that there is no equality in the current legislation and it evidently discriminates based on religion. Third, this bill leads to demographic threat to indigenous communities in northeastern and other states. Mainly, it violates Assam Accord of 1985 and contradicts NRC exercise. Critics says that on the one hand, government must adhere to Assam Accord and complete NRC exercise by identifying illegal migrants and deporting them. But on the other hand, it is bringing Citizenship Amendment Bill to give citizenship to illegal immigrants from Bangladesh, Pakistan, Afghanistan. Isn't it contradictory? Here, to remind you, NRC is a document containing the name of all Indian citizens of Assam. Initially, it was prepared in 1951 following the 1951 census. Now it is updated as per Supreme Court direction to comply with Assam Accord of 1985. This exercise has excluded nearly 19 lakh people. Even there is an apprehension that government is bringing this bill to accommodate these excluded people except Muslims. So by combining NRC exercise and Citizenship Amendment Bill, it is evident that only illegal immigrants from Muslim community are being excluded. Even though scientific community welcomed the bill's objective to provide refuge to persecuted minority from neighboring countries, it objects to the use of religion as a legal criterion for determining the Indian citizenship. This will greatly strain the pluralistic fabric of the country. And many even question the need and timing of the bill. Looking at the state of our Indian economy, employment, health status, education, and farmers' fate, this bill doesn't make any sense at this moment. Now, the question is it wise to think about persecuted religious minorities of some other country when our own women are getting persecuted, raped, burned, and murdered by our social fabric of patriarchy? Exactly, women's safety and security is the need of the hour. On a political note, many opposition parties alleged that this bill has been brought to the table only for the sake of getting votes of illegal migrants. And lastly, pertaining to OCA card holders, even minor offences committed by them will lead to cancellation of OCA registration. In the current scenario, it is very important to encourage our Indian diaspora for the well-being of our country. So this move may be against the demands of our diaspora. On the other side, Home Minister of our country defended the bill and said it would protect the boundaries of the country and northeastern states would be protected from the bill through 6th schedule and inner line permit. He defended by saying it will not violate Article 14 as we are talking about three Muslim countries and their persecuted minorities. So obviously we have to exclude Muslims from this and they are the one who are persecuting other communities. But as a counter to this, opposition asked about the Muslim sects such as Ahmadiyas and Shia who are also persecuted in those countries. To take it further, Tamils from Sri Lanka, Gorkhas from Nepal, Rohingyas from Myanmar, and even Uyghur Muslims from China are not included in the bill, and this clearly indicates the biased nature of the bill. Finally, he even said the mistakes of partition is being corrected through this bill, and bill also helps in distinguishing refugees and infiltrators. But actually, the demand for partition on the basis of religion was from Muslim League's Muhammad Ali Jinnah and Hindu Mahasabha's V.D. Savarkar. But considering the numbers in Rajya Sabha, the bill will be passed and even gets President assent to become an act. But looking into the criticism, it is very clear that countless public interest litigations will come to Supreme Court. So we need to wait and watch for the Supreme Court's decision. That's all in this presentation. Thank you very much. This video is presented to you by Manovidya IAS.